I would like to allow Mr. Reinders to perhaps comment on some of the remarks made. I mean, I must say that from the part of the CCBE, we have been extremely grateful on the way we have been able to collaborate with the Commission at operational level and also at policy level on the developments of e-justice. And yes, as indicated by Jiri, we are obviously keen to continue that collaboration. And so, indeed, it would be interesting to know if part of the strategy would also be to see, of course, not only lawyers, but also to see how this collaboration among different legal professions in Europe can be also perhaps supported and stimulated for the future development of e-justice.
No, thanks for the comments made about the digitalization of justice and maybe the way forward. Of course, we want to continue to organize a good collaboration with all the different actors. First of all, I want to say that in my portfolio, I need to work very closely with the member states, and it's the first comment that I want to give, because of course, it's very important that all the member states, and maybe also the candidate countries and some partners out of the European Union, are sure that they need to place digitalization of justice as a very high level of priority in their investment priorities for the next year, because the resilience of our societies are in line with the resilience of the healthcare system. We have seen that during the COVID-19 crisis. It will be important to work on the resilience of our economy, but the justice system is also very important, not only to have a correct access to justice, but also to defend, I said, the rule of law, and to defend the capacity for the citizens, the businesses, to go to justice if they have a problem, also with the authorities. And so you need to have an independent judge, a qualified one, but you need also to have effectiveness. And I must say, in the last years, we have seen different problems, like the length of the procedures in some sectors, in some member states. Of course, with the digitalization, it must be possible to work more efficiently, maybe in a more short period of time than we have now with the length of some procedures in different member states. So the first relation is with the member states, because without a real involvement of the member states in the investment in justice systems, we will have a huge problem. Of course, it's possible to us to take part in the process, but the main responsibility is in the hands of the member state. The second element, we want to continue to collaborate with the professionals and the practitioners. And it's sure that we will do that. About e-Codex, I said it was the case, but also to better understand what are the needs and the concerns of the practitioners. Because we need to put into place efficient tools, digital tools, but we need also to protect some elements. And I was very pleased to listen about the confidentiality between the lawyers and the clients, but also about the different kind of element of data protection, of secrecy, because of course we will have to pay attention to all those issues when we will develop in the entire Europe the digitalization of justice system. And certainly it's very important for all the different actors, but certainly more in criminal cases than in others. And there we need to be very cautious about the situation. Maybe it will be possible to use encryption in some cases to organize a real confidentiality. Maybe we have other kind of possible developments. And I want to conclude to say that we are very open to discuss about the way forward after e-Codex, because it's true that we have asked to EU-LISA, to be short, to take over e-Codex in the next years. And to do that, we need, of course, to have a real specific governance inside such an agency for the justice field, because EU-LISA is working from the concrete home affairs, so for Europol and the police systems. So we need to have a clear, separate governance inside EU-LISA about the justice system. But we need also to know what are the priorities for the next years, and what are the possibilities, of course, to invest in those priorities. That is a question of the budget, discussion now between the Parliament and the Council in the MFF and the next generation EU. And of course, we need also to conclude sometimes the European Parliament that it's needed to use better some digital tools. I was interested by the comments about e-evidence for the lawyers, but you know that we are working on e-evidence to give an access to the law enforcement authorities and the prosecutors to e-evidence in another member states to directly to the providers. And we try to start a trilogue with the Parliament and the Council on this since some time. It seems to be difficult due to the COVID-19, but maybe also due to some restrictions at the Parliament level about such a kind of possible regulation. So again, no, we are very pleased to work together on such an issue, and we'll be very pleased not only again to understand better the needs that you have and that other practitioners may have in the development of digital tools, but also the concerns that you may have, because I know that we will have specific challenges about privacy, data protection, confidentiality, secrecy, and a lot of issues, and we need to work on it, and maybe to try to have a common minimum standards at the EU level. You said that maybe with a code of conduct, maybe with a regulation, we will see, but it's important to exchange on it and to know what are the main goals in the investment of technologies, but what are also the main concerns and what are the needs to protect some kind of elements in the way to work as a lawyer, maybe in the near future with digital tools.
Thank you. Those comments are really reassuring for us. I want to also give the opportunity now for participants to ask questions. So for people who would like to ask a question, there is an opportunity to request the floor, and then we can admit you on the floor to then raise a question, make a question. You cannot, so until you are accepted to the floor, you cannot activate your microphone or camera. So you first need to request the floor before being able to speak. I don't see immediate questions arising, if I am correct. Yes, there is Ian Mitchell. I will admit him on the floor. Ian Mitchell is a well-known person within the CCB. He's the chair of the surveillance working group and has been also closely involved in our policy work in the field. Ian, please.
Yes, thank you. I particularly welcomed Commissioner Reinder's comments about the importance of ensuring legal professional privilege, but it does occur to me that there can be a degree of sort of almost siloization between directorates of the Commission. And one thing which is of a considerable concern to the CCBE is the proposals on the recovery of electronic evidence, cross-border recovery. I won't go into great detail on some of our principled objections to the present schemes, though they're well reflected in both the LIBE report and the Centre for European Policy Studies report, to which also the CCBE contributed. But the very specific matter, which I think does arise out of the Commissioner's comments, is the issue of maintenance of legal professional privilege and professional secrecy, because quite simply the architecture of the thing, and without the enforcing state judicial supervision, it in practical terms is just really quite impossible for an ISP to know whether or not particular material will be protected by legal professional privilege. And that remains a concern of ours. I mean, to be fair to the Commissioner Reinders, a rather more focused question is really, can one ensure when the present proposals for digitalization of justice are going through, that a proper priority is given to maintenance of professional secrecy? And I know Commissioner Reinders is committed to that. But can he work on convincing his colleagues in other directorates general in the Commission?
No,
that was the question, essentially.
Thanks for the remark. Of course, I'm working with the colleagues in the Commission to see what are the limits in that, and I'm sure that you are speaking more maybe about Home Affairs and enforcement authorities and the relation between Europol and Eurojust. But I want to say that it's my privilege, maybe, to have a discussion with many stakeholders in the justice system. And I'm sure that we need to find the right balance. Certainly not about the secrecy and the privilege, like you said, of the lawyers, but about the way to have an efficient justice system in criminal matters and a real fair trial and a real possible exercise of the right to defense. I explain it with e-evidence. E-evidence, if you look to the situation now, in maybe 80% of the criminal cases, we need to have e-evidence in the dossier. Without that, it's impossible to go further. And of course, if we have a trust among member states in the European Union, it must be possible for one prosecutor, to be concrete, in one member state, ask to a provider to store the evidence for a longer period of time than just some days, and it must be possible to have an access to such evidence in a criminal case. Of course, I'm very open to discuss about some additional safeguards if we want to be sure that it's a real prosecutor and it's not maybe another kind of actors at the public level. But I'm just asking the European Parliament and maybe also to the professionals to have an efficient tool. But of course, it's not because you have a direct access to evidence in a provider that it's impossible to organize a fair trial and to organize a correct relation between the lawyers and the client. And so that's the difficulty that I have. I must say that I have a contradiction in my portfolio because I need to help the prosecutors to be efficient in the effectiveness of the justice system, but I need also to organize the protection of personal data. I need to organize a protection of the privilege, like you said, of the lawyers, and so on. So there are many contradictions in the way to proceed. And the real important step in the way to install the digitalization of justice is to find the right balance between all those different objectives. And again, the reason why I'm sure that we need to have a good collaboration on this, and we need to exchange on this. So we'll come with a communication on digitalization of justice in December, after the conclusion of the council. And I'm very open to exchange again with all the practitioners about the details of such a communication. And of course, the devil is in the details. It will be application by application and exercise by exercise. It will be needed to see what are the possible safeguards put into place. And with new technology, because I said, to give an example, confidentiality of the talks between the lawyer and the clients. We need maybe to use encryption, but you know that there are many possibilities not to use encryption. But is it possible to use a specific encryption for such a kind of conversations without any access for other kind of actors in the justice system? That's the way that we are proceeding now, as with phone calls and with correspondence. But of course, with digital tools, it would be maybe more technical and more difficult to organize. But I'm very open to engage in such a way to see how it's possible in the online world for justice to stay with the same guarantee than in the offline world. That's the same issue that for many other activities in the new society that we are living in.
Thank you.
Thank you. I don't see other questions immediately rising, but I see also Mr. Lopez Aguilar. He is already online, and since the Parliament was also mentioned in your presentation, I wanted to allow him, perhaps, if he wishes, to respond or to also get involved in this discussion. He will be in the next session. He will give a presentation on the work of the LIBE Committee, in particular in relation to the use of AI. But Mr. Aguilar, just to let you know that if you wish also to engage in this discussion, please take the floor. And let me see, I think your mic and camera are not activated. I can activate that. Yes, Mr. Aguilar, please.
Good morning, everybody, if you hear me.
Yes, we hear you well.
Yes,
And you also.
I'm intending to present the views of the European Parliament, of course, of the LIBE Committee, which I chair, in this regard: artificial intelligence, digitalization, justice. But the only point I would like to anticipate is that I am personally and politically convinced, I have always been, I'm a former Minister of Justice, that the realization of all fundamental rights which are involved in the justice area through judicial remedies takes defense, takes the right to defense in the first place, in the very forefront. So digitalization of justice, with no digitalization of access to justice provided by counsel, by legal counsel, by legal professionals, by proper legal training in digital literacy from legal professions, including bar, solicitors, barristers of all kinds, despite the differences between the legal systems across the European Union, would be a goal impossible to achieve if there is no coordination between the strategy of digitalization of the administration of justice, the judicial administration, and judiciaries on their own, in connection and interoperability with digitalization, which is to be carried out by the legal professions, by bars and solicitors. So the strategy has to encompass both poles, interconnected. Otherwise, it wouldn't make any sense. That is the point I would like to anticipate.
Thank you. Are there any comments on that, Mr. Reinders, perhaps?
Yes. I will have a meeting now with the Minister of Justice from a candidate country. But I want to say that it's true that we need to organize such interoperability. I've said that in my introductory remark. And I will try to see, after the publication of the communication on digitalization, or it will be possible to, again, to exchange on those with the professionals. But I'm sure that I will go also to the LIBE Committee to discuss on this, because I know the real interest of the LIBE Committee and the President, of course, about this kind of possible evolution. But we need to work with new tools. We need to work with the digital instruments that we have at our disposal. And again, we need to do that with the same kind of protection that we have organized in the offline world, in the online world. And it's the same for many different kind of discussions that we have at the moment. But of course, sometimes it's very technical to do that. But I'm very pleased to see that we have the opportunity to discuss this this morning, and that we will continue to organize a good collaboration with CCBE in the near future. Thanks a lot for such an opportunity, and I will continue to discuss now not only with the Parliament, but also with some Ministers of Justice in the field of digitalization of justice. Thank you.
Well, many thanks to you, and we look forward as well to the continuing collaboration. And yes, thanks again for your time to participate in this.
Bye-bye.
Thank you.